Imagine Satterthwaite Construction Limited has just invested millions into a prime commercial plot. The site is prepared, the crews are scheduled, and then the entire project grinds to a halt. A neighbor has stepped forward, claiming a legal right that could stop the build permanently. A review of the documentation reveals 3 specific encumbrances: an estate contract from 1989, a restrictive covenant dating back to 1922, and an occupying spouse claiming a beneficial trust interest in the property. This land belongs to the 10% of titles in England and Wales that remain unregistered. In this system, there is no central land registry to guarantee a clean title or provide a definitive list of the burdens on the estate. To prove ownership, the seller must produce a physical, chronological chain of conveyances. This chain must stretch back to what the law calls a good root of title, a deed that is at least 15 years old. This 15-year requirement is mandated by the Law of Property Act 1925, Section 44. Determining whether Satterthwaite is bound by these rights requires testing them against a bifurcated legal framework, the strict registration rules of the Land Charges Act, and the historical equitable Doctrine of Notice. This bundle of historical conveyances is the epitome of title. A solicitor reviews every document to confirm the legal transfer of the estate. These decades-old papers are also the primary record for discovering third-party rights, like covenants, easements, and mortgages. This reliance on paper creates significant risks. Deeds can be lost, records can be missing, and certain equitable rights, like those belonging to a spouse who contributed to the purchase price, may not appear in the written documents at all. Because the paper trail is vulnerable, the Land Charges Act 1972 was enacted to bring specific rights into a public register. It creates a system where failure to register a right can result in that right being legally destroyed. The Land Charges Act 1972 is the statutory regime governing specific equitable interests. It is designed to be certain, objective, and strictly enforced. The register is organized by name, not by land. Third parties register their interest against the estate owner's name. Section 2 lists registrable interests, including Class C4 estate contracts, Class D2 restrictive covenants, Class D3 equitable easements, and Class F home rights. Under the Law of Property Act, Section 198, registration constitutes actual notice to the entire world. Once a charge is registered, every subsequent purchaser is legally deemed to know it exists. However, Section 4 of the Act states that if a registrable interest is not registered, a purchaser for money or money's worth takes the land free of that interest. Midland Bank Trust Company Limited v. Green demonstrates just how strictly this statute is applied. The court had to decide if a buyer who had actual knowledge of an unregistered option to purchase was still bound by it, even if they bought the land at an undervalue. The House of Lords held that Section 4 of the Act is absolute. If an interest is not registered, the purchaser's state of mind is irrelevant. In this case, a son failed to register a Class CIV charge for his option to buy the family farm. When his father sold the land to the mother for £500, the mother's actual knowledge of the son's option did not matter. The mother took the legal estate free of the option, because the statute requires registration, not just awareness. This leads to a vital rule for any examiner. If an interest is registrable under the Land Charges Act, the equitable Doctrine of Notice cannot be used to save it. The statute replaces the uncertainty of a buyer's knowledge with the mechanical certainty of the register. Interests that fall outside the Land Charges Act, such as beneficial interests under a trust or covenants created before 1926, are governed by the older pre-1926 rules. Under these rules, legal interests are absolute. They bind the whole world, regardless of a buyer's knowledge. Equitable interests, however, bind everyone except a person the law calls equity's darling. To achieve this status, a buyer must be a bona fide purchaser who provides value to acquire a legal estate, and does so without notice of the equitable interest. Notice includes actual knowledge, but it also extends to constructive notice under Section 199 of the Law of Property Act. This strict rule binds a buyer to any facts they would have discovered if they had made reasonable inquiries and inspections. The case of Kingsnorth Finance v. Tizern shows the high standard required for these inspections. The issue was whether a lender was bound by the unwritten trust interest of a spouse who lived in the property, despite the lender not having actual knowledge of her presence. The court ruled buyers and their agents are fixed with constructive notice of an occupant's rights if they fail to conduct a thorough physical inspection and ask the necessary questions. Because the lender's agent performed a cursory inspection and ignored signs of the wife's occupation, the lender was fixed with imputed notice through their agent's failure. The lender failed the test for equity's darling and was bound by the spouse's interest. It is also important to identify volunteers, those who inherit or receive land as a gift. Because they provide no legal value, they can never be equity's darling and are always bound by prior equitable interests. Outside the statutory register, the law requires a buyer to be a diligent investigator. Carelessness in inspection is penalized by the automatic application of notice. We can now apply these rules to resolve the Satterthwaite construction scenario. We analyze the three encumbrances by first determining which legal regime applies to each one. The first encumbrance is the 1989 estate contract. This is a Class C4 land charge under the Land Charges Act. Applying the Midland Bank rule, if this contract was never registered, Satterthwaite takes the land free of it. Their actual knowledge of the contract in the deeds does not make it binding. The second encumbrance is the 1922 Restrictive Covenant. Because it was created before 1926, it cannot be registered as a land charge. This falls under the Doctrine of Notice. Since the covenant is clearly visible in the Epitome of Title, Satterthwaite has actual notice. They are not equity's darling and are bound by the restriction. The final encumbrance is the occupying spouse's beneficial interest under a trust, which is also unregisterable under the Land Charges Act. Under the Kingsnorth rule, Satterthwaite would have constructive notice of this interest due to the spouse's physical occupation, meaning they would typically be bound by it. However, there is a specific statutory mechanism that can detach this equitable interest from the physical land itself. This tool is known as overreaching. To overreach, Satterthwaite must pay the purchase money to at least two trustees. If they do, the spouse's equitable interest is legally severed from the land and moves to the money instead. Satterthwaite takes the property free. When analyzing unregistered land, prioritize the statutory check. Verify if the interest is registrable under the Land Charges Act before applying the Doctrine of Notice.